Thank you very much, gentlemen of the press. Good evening and welcome to our offices. Thank you for coming this afternoon for the purpose of this press briefing on behalf of proposed as Emir of Kano by the Governor of Kano State, His Excellency Dr. Abdullahi Umar Ganduje, who claims to have acted on a resolution of the Kano State Executive Council. This action, in our view, is illegal and unconstitutional. The Kano State Executive Council, rather the Kano State Emirate Council law, which was recently enacted by Kano State government, does not give the State Executive Council or the Governor of Kano State the powers to unilaterally remove the Emir. The reason given in the letter of deposition of the Emir dated 9th March 2020 was alleged, quote, disrespect to lawful instructions from the authorities, unquote. The Emir was also alleged to have, quote, refused to attend official programs and meetings organized by the government, unquote. As far as we are aware, there has not been any notice of such disrespect ever given to the Emir or query issued to him for refusal to attend official functions. He was never given any opportunity to defend himself against those charges. Section 13 of the Kano Emirate Council Law 2019, cited in the letter of deposition, empowers the governor to depose an emir only after due inquiry and in consultation with the State Council of Chiefs. We are not aware of any such due inquiry, nor are we aware that the Kano State Council of Chiefs was at any time summoned to any meeting, much less discuss the removal of the emir or give any advice to the governor on the deposition of the emir. Muhammad Sanusi II was the chairman of the State Council of Chiefs, and if such a meeting was summoned, he would have been aware. He would have informed us. In our view, the action was patently illegal and unconstitutional and a clear abuse of power. Be that as it may, the decision to challenge the removal is solely that of the Emir, Muhammad Sanusi II. At this moment, no such instruction has been given to us. Since the deposition of the Emir, I was at the palace yesterday afternoon in the company of one of my senior colleagues to consult with the Emir. We met him in good spirit and in company of his family and a few associates. He said to us that he was waiting for the deposition letter from the government house and was informed that the Commissioner of Police was on his way along with certain government officials. While waiting there was a commotion in the private wing of the palace as some unauthorized person tried to gain entry into the family section. This led to some scuffle and tear gas were fired by the security operatives. Normalcy was restored after the unauthorized persons, along with armed security operatives, retreated from the inner part of the palace. I subsequently, along with my colleagues, was able to meet with the Commissioner of Police, that is the Kano State Commissioner of Police, and other security operatives, and with the permission of the Emir, they were led to one of the sitting rooms where the deposition letter was served by an agent of the state government on him. The Emir accepted the letter and decided to acknowledge it personally. After writing some Quranic verses on the acknowledgement copy, in the Arabic script of course, along with his signature. This was handed over to the government official. In the letter of deposition, it was stated that the Emir was to be removed to Nasarawa State. We requested to know if the Emir was under arrest, and if so, we wanted to see the arrest warrant. The Commissioner of Police informed us that the Emir was not under arrest. We informed the Commissioner of Police that it was illegal and a violation of his constitutional rights, that is the rights of the Emir, to remove him to Nasarawa State against his wish. The Emir informed the Commissioner of Police that his friends had sent an aircraft to fly him along with his family to Lagos, and requested that they should be provided with necessary security cover to the airport so that they could leave. The Commissioner of Police refused, saying that was not their instructions. They were willing to allow the family to leave for Lagos, but the Emir was to be flown to Abuja, then on was taken to Nasarawa State. It was clear to us that both the Emir and ourselves were helpless, and the police and other security agents were willing to take any measures, including the use of force, to achieve their objective. In order not to jeopardize the safety of the Emir, or the safety of any member of his family, or indeed other persons around, the Emir decided to cooperate and proceed in the vehicles provided by the operatives to the airport. We accompanied him with the Commissioner of Police to the Nigerian Air Force military base in Kano, where the Emir was put in a private aircraft and departed to Lagos departed at 6:40 p.m. The family subsequently boarded the aircraft arranged by his friends and departed for Lagos at about 15 minutes afterwards. Gentlemen, we have not spoken to the Emir since yesterday, but we understand that they're at their destination somewhere in a remote part of Nasarawa State after driving for nearly 7 hours yesterday night and arrived at their destination at 2 a.m. This morning. We understand the choice of the location to detain His Highness Mohammed Sanusi II was intended to cause maximum trauma and distress. This again is illegal and unconstitutional. According to instructions we received from the Emir through his Chief of Staff, we are directed to take legal action to challenge the legality of the Emir's detention and banishment. We are of the firm view that this action is illegal and unconstitutional. Section 35 of the Constitution of our country guarantees every citizen the right to personal liberty. The basis of the denial of personal liberty are set out clearly in that section of the Constitution. None applies to the case of the Emir. The archaic practice of banishment of deposed emirs, a colonial practice, has no basis under Nigerian law or the Constitution. We are totally perplexed at the resort to this practice in present-day Nigeria by its political leaders. The illegality of this practice was pronounced by the Nigerian Court of Appeal in the case of Attorney General of Kebbi State against His Royal Highness Al-Haji Al-Mustafa Jokolo and others, which is reported in the law report, citation given here, 2013, Local Bill and Electronic Law Reports 22349/Court of Appeal, where the court pronounced it as illegal and unconstitutional and a gross violation of the rights of the Emir. This is what the Court of Appeal said in that case. The banishment and deportation from Kebbi State by the governor of Kebbi State, of the first respondent, that is the then Emir of Gwandu, Second Gwandu, to Lafia in Nasarawa State, and later on to Obi, also in Nasarawa State, is most unconstitutional and illegal, unquote. We call on the authorities, in particular the Inspector General of Police, the Director General of the Department of State Services, and the Attorney General of the Federation and Minister of Justice, to ensure the immediate release of His Highness Mohammed Sanusi II so that he can be reunited with his family. We are concerned about the personal safety and security of His Highness at the remote location where he is being held, and wish to call on all well-meaning Nigerians and the international community to bring their influence to bear to ensure that His Highness Mohammed Sanusi II regains his liberty immediately and to guarantee his safety and security. The legal team of His Highness are working both in Kano and Abuja, and unless he is released immediately, will be taking appropriate legal action. Thank you, gentlemen of the press. This is the statement we are issuing on behalf of His Highness, and we are now ready to take questions.
Please introduce yourself and the media you are here.
Identify yourself.
Team both in Kano and Abuja are already working, and if by tomorrow morning no good news is received by us about his release, we'll then be approaching the courts appropriately.
Yes.
That there is any warrant to arrest him or to detain him by any court of law. But of course, as things stand at the moment, we can say that he is being kept in custody unlawfully. Yes,
Kept in
my name. You know, His Highness has been facing unwarranted allegations of corruption by the Kano State Public Complaints and Anti-Corruption Commission. And on his instruction, we have filed a number of cases, some of which have been resolved in his favor. And as of last Friday, we were in court in respect of one of them, and an interim order was issued restraining the commission from inviting him to appear before the committee, or the commission. So there are a few cases that are pending, but the one that concerns the emir directly, those against the Anti-Corruption Commission. It was very clear in my statement that although we take the view as lawyers that his removal was illegal and unconstitutional, we have not received any instruction from him to challenge his removal from office as Emir of Kano. However, we have instructions from him to challenge his unlawful detention or custody. And that's what we are calling on the authorities to do, that is to release him immediately and unconditionally. And unless that is done immediately, then we will be approaching the courts by tomorrow.